Good afternoon. It's Free Legal Advice Friday, and I'm about to go into court in about 15 minutes on a Second Amendment case. And so I thought I'd do a Second Amendment issue for this Friday's edition of Free Legal Advice Friday and just quickly explain the West Virginia Stand Your Ground Law, also known as the Castle Doctrine. And what does that mean? What does it not mean? Well, first of all, basically all it means in West Virginia is that there's no duty to retreat before using self-defense under certain circumstances. Primarily, this has to do with your home. So it used to be, and still is in some states, that say a home invader breaks into your home, they're trying to kill you, and you are required to escape if you have the opportunity, or lock yourself in a safe room, whatever. And if you chose not to do that, then you couldn't use the self-defense defense. In West Virginia, clearly that is not the law anymore. There is no duty to retreat if there's a home invader. That's basically what that means. It does not authorize you to shoot just anyone who walks through your door. It does not allow you to shoot somebody dead outside the home under, any other circumstances. It basically just does away with the duty to retreat. It comes up actually very rarely in real life. There was a 2015-2016 case out of the Huntington area called the Lemaster Case, where the stand your ground defense went to a jury. And I actually looked up the jury instructions themselves. I got them from the clerk's office, and I can actually read it to you. So this is the extent of the law as it was explained to the jurors in the Lemaster case. The judge said to the jurors, an intruder is a person who enters, remains on, uses, or touches the land in another's possession without the possessor's consent. Our society recognizes that the home shelters and is a physical refuge for the basic unit of society, the family. A man attacked in his own home by an intruder may invoke the law of self-defense without retreating. The occupant of a dwelling is not limited in using deadly force against an unlawful intruder to the situation where the occupant is threatened with serious bodily injury or death, but he may use deadly force if the unlawful intruder threatens imminent physical violence or the commission of a felony and the occupant reasonably believes deadly force is necessary. The violent and unlawful entry into a dwelling with intent to injure the occupants or commit a felony carries a common sense conclusion that he may be met with deadly force. So, that was the stand your ground law as actually read to a jury in a murder case in West Virginia. And one of the only instances of it being used that I'm aware of, maybe one other that I know of. So, if you have a situation where you have a home intruder, that's exactly probably what the jury would be told. So it still comes down to not just is somebody crossing the threshold of your home, but are they an intruder? Are they coming in to commit a felony or to possibly hurt somebody? If that's the case, you can smash their skull with this tomahawk. You can shoot them however many times probably you want to, so long as it's still close in time to the danger. So you're allowed to use deadly violence where you have an intruder in your home. You do not have to retreat. You don't have to try to escape. You don't have to lock yourself in a safe room. You're allowed to use self-defense. That does not mean that you can follow them out onto the sidewalk and issue a kill shot like happened in the Lemaster case, because that might land you in front of a jury, though he eventually was found not guilty. So you want to stay in your home and you want to use common sense. If somebody's breaking in your home to commit a felony inside or attack you, you generally are going to be okay under the stand your ground law. So there are actual exceptions that are included in the statute. One exception, the biggest one, is that you cannot be the aggressor. So stand your ground actually does apply outside the home. But you still have the basic rules of self-defense. So one of the biggest rules of self-defense is you can't go start a fight, you can't go start a fist fight and then end it with a gunshot. You can't be the aggressor and then claim self-defense. So you can't start a fight, the guy's beating you up, so you pull your gun because you're afraid of imminent serious injury and you shoot him. You can't do that because you were the aggressor. Now, there's an exception to that exception sometimes. If you attempt to withdraw and the other person didn't let you withdraw, you really had no choice, but you don't want to find yourself in that situation. So that's the reason you're carrying a gun. You never want to get in any sort of altercation, never want to get into a fight. The other big exception is you need to be lawfully where you're allowed to be. You don't want to be trespassing somewhere, and you need to be lawfully doing something that you're allowed to do. So you don't want to be robbing a gas station. You cannot use the stand your ground defense if you rob a gas station and the clerk shoots you, or you shoot the clerk. So you can't use it if you're committing a felony or escaping the commission of a felony. You have to be basically minding your own business where you're allowed to be, especially in your home. And that's primarily where the Castle Doctrine or the West Virginia Stand Your Ground law applies, is in your home. And the other thing about the statute is it gives absolute immunity to the homeowner if they shoot an intruder. So you can't be civilly sued if you are effectively able to use the stand your ground defense. And I'm not sure how often that ever happened in real life anyways. So the statute itself is West Virginia Code 55-7-22. And you can read it for yourself. It's pretty simple. And the exceptions are also listed in there. And again, that applies basically to you can't provoke it, and you can't be doing something wrong. So that's the West Virginia stand your ground defense, and it's actually pretty rare, and it's all basic self-defense anyways. You never want to use deadly force unless you believe that there's an imminent threat to the safety or serious injury or death to yourself or someone nearby. So, that's self-defense. Basically, it applies to civilians, it applies to police officers. There always must be some imminent threat there. So, don't misunderstand that it has to do with property. Remember, in West Virginia, you cannot use deadly force to protect property. You can't set up a spring gun. You can't electrify wires to keep crackheads from stealing the wires. You're not allowed to use deadly force to protect property. You're just not. You should. In my opinion, in Texas, I believe the law is that they can shoot people for trying to steal their car at night. So, that's not the law yet here in West Virginia. Maybe we want to talk to the politicians about that. Maybe we should be able to use deadly force to protect personal property, private property. But as of right now, you can't do it. Deadly force is to protect people, protect each other. So that's the short of it. If you look at the link that I'll attach on my blog, I put the actual jury instructions that were used in the Lemaster case. I have a link to the statute. I have a link to some other things if you want to read more in depth about it.